Welcome to Sidebar, Bracewell's podcast devoted to government enforcement and investigations, corporate compliance, and white-collar criminal defense. I'm Matthew Nielsen.
And I'm Seth DuCharme.
And we are your hosts and both partners at Bracewell LLP, where we represent companies, boards of directors, and individuals in all manners of litigation, investigation, and enforcement actions. Seth, who do we have joining us today?
Yeah, thanks, Matthew. And really today it's my pleasure to introduce someone who I know you've had a long and productive professional relationship over many years. Today we're going to talk about an important but sometimes overlooked part of investigations, the role of the outside auditor. Joining us is Jeff Ferguson, who's a partner with Ernst & Young in its forensic and integrity services practice. Jeff has more than 2 decades of experience in fraud and forensic investigations that include manipulation of earnings and financial results, embezzlement by company officers, fraudulent billing schemes, and foreign bribery matters. Among his more notable matters, Jeff assisted the government in building its case against and testifying as an expert witness in the prosecution of Alan Stanford and his cohorts in the infamous Stanford Financial $7 billion Ponzi scheme. So, Matthew, it's great you were able to secure Jeff's appearance with us today. And Jeff, especially thanks to you for being able to join us today.
Thank you for having me.
Yeah, I've had the pleasure of working with Jeff and his team on projects for probably more than a decade now. And the best part of that is over that decade, my TCU Horned Frogs have dominated his beloved UT Longhorns in football. So normally we have the leg up on the bragging.
It's sad but true.
Well, Jeff, let's get started talking about kind of the auditor role in internal investigations. You know, for those who are familiar with the term, there's something called a shadow investigation that I know you're involved in a lot. Can you just tell us what that is, what happens, how it comes up, and just will you start us off there?
Sure. So, when we have an audit client that has a concern about, some kind of fraud, maybe there's a whistleblower complaint or something like that, and our audit client needs to perform an investigation, we, as the audit firm, perform what's called a shadow investigation. And really what that means is the audit team will bring in the forensics practice kind of as specialist of the audit team. And what we do is we evaluate the the investigation team, as well as the investigative process, such that when the investigative team, comes to some conclusions as to, who did what or who all was involved, things like that, we as the auditors can rely upon those conclusions. And so a shadow investigation really is the evaluation of the investigative team and the investigative process.
And why is it necessary for you to get involved on behalf of the audit team?
Well, a lot of times when a shadow investigation is called for, we're dealing with allegations that could affect the C-level client. So, C-level, CEO, CFO. And so when we're dealing with that, we're looking at, management integrity. And that's something as the auditors that we have to rely upon. The auditors take representations from management of their audit clients, that the financial statements are correct and things of that nature. And so relying on management integrity is fundamental to any audit. And so if we're dealing with questions of management integrity or, questions as to the accuracy of the financial statements, the allegations involved, incorrect financials, we have to be able to rely on the investigative conclusions, and therefore we need to make sure that the investigative process was adequate.
So what is your role as the shadow investigators versus the investigation team that's been hired by the company or whatever, maybe audit committee or what have you?
Yeah, that's a good question. And that's something we try to address early on in the process when there is some concern at an audit client and the forensics team is brought in to do the shadow investigation. One of the first things we do with the investigative team and with with the client, and typically we're dealing with the general counsel's office at the audit client. We make it clear to them that as the shadow investigative team, we are not here to perform the investigation. We are not here to re-perform any investigative steps. We're here to evaluate the process, to evaluate the investigative team so that we can rely upon the results, whatever those results may be. And so we're not the fact finders. We're just making sure that the process is such that we can rely on the judgment and the conclusions of the fact finders.
Jeff, I'm just curious, when you're doing these types of investigations, how often are you doing them contemporaneously with some outside agency, conducting an investigation? Are you doing it, either in preparation for that or with an awareness that the ultimate work product that you might be producing will at some point be part of a deliverable, to a regulatory agency or an investigative agency? Or is it principally for internal purposes?
Well, a shadow investigation is for internal purposes. We are a part of the audit team. Our work papers become audit work papers and things like that. We are not presenting findings or conclusions or anything like that to any outside agencies. We're working strictly with our audit teams and our professional practices group. And really, the subject matter that we're focused on is the quality of the investigative process. There are various ways that an investigation can start, some of which include, inquiries by the government or inquiries by regulators that may be the beginnings of a audit committee investigation. And in those instances, the investigative team that the client would hire, the outside attorneys, they are presenting findings potentially to regulators or to the government. And one thing I'll mention is, kind of what I call my day job is actually doing those types of investigations, right? It's not just doing shadows. And hopefully we're not doing very many shadows because that means we don't have many audit clients with those issues. And so, one thing as the investigators or the investigative team, one of the things you have to do at the very beginning is understand who your constituents are. Who are you going to be reporting your findings to, right? It's important to know that, we're reporting to, say, the audit committee or to the board or sometimes to the general counsel of the client. Certainly they're a constituent, but if regulators are involved or the government enforcement is involved, you need to understand that from the beginning as well. And, as the shadow investigators or part of the audit team, the auditors are constituents, and you need to understand what your constituents' concerns are going to be at the beginning of any investigation, right? Because those concerns or those questions that you can foresee, you're going to have to go find those answers. And so I think it's really important at the beginning of any investigation, certainly when I'm doing an investigation, we identify who are we going to be reporting to and what questions are they going to have. When I'm doing the shadow investigation, I'm the one that I'm part of the audit team. And so now we have questions we need answered, right? And so you're kind of on the other side of that coin, if you will.
Well, and that's an important point here, right? Is you have to, as an investigator, understand kind of what's your end goal, and those can be varied. And so if you're doing the investigation, you may need to be doing it to the satisfaction of a government agency as part of cooperation, so forth. But, when you're dealing with, when you have your shadow investigation hat on, or you're dealing with that team at the auditor, I mean, look, let's be very clear here. The goal is so the client can get out financial reports that are potentially due, whether it is if it's a private company. A lot of times I've done investigations where the auditor, there's still an issue because they have banking covenants and they need to get it out to banks, or in the public setting with either quarterly or annual financial filings. Ultimately, if you don't get Jeff or at another firm, his contemporary comfortable with your investigation, your findings, ultimately your auditor's not going to sign your financial statements, right? And then you have all sorts of collateral issues that can stem from that.
So it's like the ultimate stamp of approval, and just in terms of a quality control to the process and the end product. Is that essentially what your end state is, Jeff?
Yeah, I think that's a good way of putting it. And the standard by what that we're measuring against is also important to understand. What we are looking for is a reasonable investigation, right? It's not necessarily the investigation that I would have performed. It's not the A+ investigation, but it is reasonable. And so it is, at the end of the day, if I am the partner on the shadow investigation, it is my judgment as to whether or not the investigative team itself was competent, was experienced, was independent or not. And that can be a sticky situation. And then the process itself was a reasonable process. And at the end of the investigation, when we are told, here's what all from an investigative process, here's what all the team has done, and here's the conclusions, I have to conclude whether or not, in my judgment, it was a reasonable investigation, and whether or not, as an audit firm, we can rely on those conclusions. And if the answer to that's yes, then then we move forward. If the answer to that's no, there can be some issues with moving forward on financial statements and things of that nature.
Well, and to that end, and kind of speaking from personal experience, and hearing Jeff both say when things went well and things didn't go so well, how you kick off that investigation can be pretty important, right? I mean, let's take a hypothetical. Company learns of potential manipulation of earnings involving senior level officials within a company that are signing management rep letters to the auditors, gets reported by whistleblower or some other method to the audit committee, who decide they need to retain counsel to conduct an investigation. I mean, pretty standard hypo there, Jeff. But one of the things that Seth and I see a lot is, how quickly do you get your auditors involved? Because from the company side, there's a concern of what I hear from clients is, well, look, unless we know there's an issue here, we don't want to spook our auditors. But I have a feeling you may have a different view of the world.
Yeah, and there's some tension there, right? I mean, and I've done the investigations where we get hired, and then those questions come up. Do we need to tell the auditors? And I understand the tension there for the client. I will say this: when we are doing the shadow and we are the auditors, obviously we want to be brought in the earliest as possible. But I understand that's not always the case, and there may be reasons why. I will say one of the things that we evaluate is, when did the company learn of the issue and when did they notify us? I've had instances where, not a common instance, but it has occurred where there have been concerns about senior officials at a company, but those concerns really had nothing to do with the financial statements, right? They may have been an integrity issue, but it wasn't financial in nature. And so the company may have said, you know what, we need to investigate it, but this really has nothing to do with the financials or anything like that. So we're not going to tell our auditors. And then, maybe a quarter goes by and we've got someone at an audit committee meeting and there's some mention of the investigation, however we learn about it. And we're like, well, wait a second, why weren't we notified of that? And a lot of times, and it happens a lot of times in the GCO's office, they just think all we care about is the financial statements, right? They forget about the management integrity questions and really being able to rely upon the people who are making those reps to us. And so those are instances where we get brought in late, or sometimes even after the investigation is over and concluded. Those are really sticky situations, because if we will then go through the investigative process. And if we don't know that it was reasonable and we don't know that we can rely upon the conclusions, we're all kind of in a bad spot. That's kind of a long-winded way of saying, my preference when I've got my shadow investigative hat on is the earlier the better. And the other part of that, the other reason for being brought in early is we evaluate the investigative team. right? And I mentioned, looking at competence and experience, objectivity of the investigative team. And along with objectivity comes sometimes independence. If you have allegations that your CEO and your CFO might be doing something inappropriate with the financial statements, and you go out and you hire your corporate counsel that you do business with every day. And, that may be hard for us to get comfortable with the fact that maybe that law firm is objective, right? Mm-hmm. Because they're not independent. They're relying on that company for a lot of fees. So there are things like that we have to evaluate. And if you get too far down the road on an investigation and then bring us in and we're not comfortable with some of that, we're all kind of in a sticky situation. So apologize for the long answer, but I think those are just some reasons why bringing the auditors in and having a conversation with them early it can save everyone a lot of time and a lot of grief, honestly.
Yeah, I mean, the whole notion of compartmentalizing management integrity issues from the reliability of financial statements seems a bit aggressive to me. I mean, particularly, we talk a lot about ESG and corporate governance and what investors care about and what, the scrutiny that's going to be applied through a number of different layers to whatever the ultimate representation is. So I suppose I don't question, the notion that it's possible to have an integrity issue that is wholly separate from the corporate governance issues and the reliabilities of the representations. But it would seem to me that if you start to see some red flags there, that it would be most prudent to act sooner rather than later. Jeff, what's the downside? I mean, obviously it creates a lot of anxiety when you bring scrutiny to a process, and there can be all sorts of, I guess, collateral costs associated. But what's really the downside about acting, early in this process to bring concerns, to the attention of the committee or to bring in, a team like yours?
Well, there really isn't a downside, but what you do have, and it usually occurs with either clients, mainly with companies that really don't have experience with these types of things, right? Which is great. Right. You don't have experience having to investigate fraud. That's not a bad thing, but it's just that anxiety, that I think people make certain assumptions that, well, we don't really know if this is true. And so if I bring in the auditors, they're going to jump to conclusions and they're going to make us do all kinds of work that we don't think we need to do and things like that. And that's simply not the case, at least in my experience, right? And I will tell you, especially if there's allegations about management integrity and allegations potentially dealing with financial statements or disclosures, does that make the audit team nervous? Of course it does, right? They've got some skin in the game too. But what I do see, whether or not the company has experience or the audit team has experience with these types of things, what we try to do is take a very reasoned approach, right? Again, we don't need to go boil the ocean just because there's a concern. We need to be reasonable in the approach and reasonable in the process. And I'll also mention that companies' auditors, for independence reasons, cannot direct an investigation. That is the job of either the audit committee, the board, or management. And the auditors cannot take on those roles. And so your auditor really can't come in and say, you must go do X, Y, and Z as part of this investigation. That would cause independence issues. I think you used the word anxiety. I think that's what it is. I think that's what people, they're anxious about the auditors overreacting or something like that. A lot of the times, though, when I take a step back after an investigation's over and I look at where we started and where we ended up, I think we do a pretty good job of making sure that what's done is reasonable. It's not overkill, but it's also a weird byproduct of it is whoever the investigative sponsor is, if we shadow the investigation and we come away thinking it was reasonable, that's kind of a nice check to have that you did do a reasonable investigation. Now, it's a judgment call. Could someone else look at the investigation and say something different? Of course. But if you have to go talk to the regulators or the government, having someone kind of look over your shoulder and say, you did a reasonable job isn't, in my view, a bad thing.
Yeah, Matthew and I have talked a lot about, the tension between, do you want to worry now or do you want to worry later, right? And sometimes doing the hard thing on the front end means you can sleep much more soundly, in your bed a few months or even sometimes a couple of years down the road if people can get comfortable with it. I mean, frankly, that's what I think hearing from you is so valuable, at least from my point of view today, because, our clients, I think the more time you have to become comfortable, with a strategic approach, and you have a little bit of time, before the emergency happens, to learn about it, try it on, and understand, especially who you're working with and how it's going to go, the less anxiety there is, ultimately in the whole process.
Yeah, I know there's anxiety, and I'm sure there have been instances in where, you had a shadow team of an auditor who just, made somebody boil the ocean unnecessarily. But I can tell you kind of the experiences that I have had are usually more of a reasoned approach, like Jeff's talking about and how he's approached things. And then he's shadowed investigations I've done. Or you have the auditors. I mean, there's some firms I've been surprised about how they weren't very interested in the allegations. And I, quite frankly, was a little stunned by it. Fairly some that were fairly serious, but at least you get that answer. Yeah. And then if you do get the boil of the ocean, at least you get it early, and maybe you can help, facilitate that conversation and get it narrowed and maybe take things by stages. Yeah. I can tell you that the bad result is what happens is, Jeff said, is that when the auditors aren't involved early, of course we won't give any details out, but, I did a shadow where the client was I did an investigation where the client was very hesitant to tell the audit committee or the audit firm, although I knew Ernst & Young was the auditor and I knew Jeff was going to be shadowing it. But I understood the anxiety, right? Because if there's an allegation that doesn't appear to be credible against somebody, that could scar them with internal people, right? With the audit committee, with the board. Right. And so I understood that. But ultimately, this particular issue did come out. Unfortunately, it was about 11 days before the financials were needed to be signed off on.
It's always the way, isn't it?
And I knew Jeff was going to call me and not be very happy. And sure enough, he did. Thankfully, we were able to get through that, and his team did a great job. I'm sure weren't thrilled with having to kind of drop a lot of things they were already doing to do this, but thankfully we were able to get that done. But it was something that probably we could have done. Maybe you can have good, fast, and cheap, but you can have two of those, but not all three, is the old saying. So you can have that time to do your investigation. That probably ended up better.
Well, in Matthew, this may sound counterintuitive, but in instances, it always seems like these things pop up right before some kind of earnings deadline or filing deadline. And so time is of the essence. And in a weird way, I have found that when we're brought in, or if I'm doing the investigation and we are working with the audit firm to report to, if you get the auditors in early, and you have frequent updates and conversations, and it is a frequent communication, the auditors can actually help the efficiency because they can you can hone in into what their concerns are, right? And what they need answered. And you can be laser focused on that as opposed to going in areas, looking in areas that may or may not be really all that important. And I think there's certain investigators, certain attorneys who have done this for a long time, and they can anticipate pretty well what the auditors are going to be concerned about. But sometimes that's not the case, right? And so it may sound counterintuitive, but sometimes having your auditors in, having the shadow team in, and say, look, these are the questions we're going to need answered. This is what we're concerned about, and knowing that and working towards that can really be a blessing when you have a short time frame to work with.
Yeah, that's exactly right. So, Jeff, give you a little bit of a platform here of maybe talking to the people who do this for a living. Of look, you've seen things done well, you've seen things done poorly. Can you hit the high notes of, and really talking kind of that early process and then maybe communicating with the audit team of what are the things you see that set an investigation up for failure versus what you see that sets it up for success vis-a-vis getting the auditor comfortable with the end result?
Yeah, to me, it doesn't all depend on how you start, but a lot of it depends on how you start. If you make some missteps in the beginning, it can be really hard to recover from. I mentioned earlier, we see companies who have an issue, they hire their corporate counsel, say, their corporate firm, and those people will pull in their white collar attorneys to do the investigation, and off they go. And that can be fine in a lot of instances, right? There's nothing necessarily wrong with that. But there could be instances where, that's not preferable, such as, again, if you have allegations against like a CFO or a CEO or something like that, and it's issues that do touch the financials or the disclosures. I mean, at that point, it would be preferable to bring in an independent counsel and that isn't relying on the company for fees annually. That helps us get over, the question of objectivity. Are they going to be objective, or are they going to not really want to report something bad on the CEO that they've been working for the last decade, something like that. So again, that's not to say that you can't go hire corporate counsel in many instances. That's fine too. But really kind of thinking through who you're going to hire. Do they have the right experience? And is that going to be something that is looked favorably upon? And so number one is hiring the right team. But number two, I see a lot of times, and I think one of you alluded to it earlier, a lot of times there'll be a question about somebody or something, and the company will want to kind of kick the tires a little bit and see if, is there really a concern here? Or if we kind of look into it and we don't see anything, maybe we don't have to do a full-blown investigation. Mm-hmm. A lot of times when that happens, you'll see the general counsel's office or maybe an internal audit or somebody like that at a company go start interviewing people, right? And the cat's out of the bag at that point, right? And if they do say, oh, wait, there is something suspicious going on, we do need to do an investigation. Well, now the subjects of the investigation may know that one's coming, things like that. And that can really cripple the investigative process. Typically, what we would prefer a company do is to lock down the data, the relevant data, whether it's people's email or files on a server or a computer, make sure that information can't walk out of the building or be deleted or manipulated in some way. If you lock down the data first before you start asking questions, it's always there if you have to go look at it. Doesn't mean you have to go look at it, but at least it's preserved, right? And so doing things like a litigation hold or sequestering data, in a competent manner is usually critical in the early stages. And so, I will see there will be times where an investigation doesn't start that way. And then we need to look at the data. And now there's questions as to the reliability of that data. And then that can be one of those, we're all in a sticky situation. And now we probably have to do more work to validate the data that we wouldn't have to had we gone in the right order. So those are some of the kind of missteps that I see early on in investigations.
Well, let's end our discussion with a favorite topic. Not really, but it is an interesting one. It's only to those of us who do this is reporting out of the investigation, right? So let's kind of step back and set the stage for people who don't do this for a living. Is that in the vast majority of jurisdictions, and there may be none to the contrary that I'm aware of, if you talk to your auditors, that is not a privileged communication. They are not your representatives for purposes of attorney-client communication. They are an independent, objective firm. And so most of the courts would say there is no privileged communication there. So if you're reporting out an investigation to the audit team, you got to worry about waiver. And if there is the governments out there, plaintiffs' lawyers, there's lots of constituents who would probably like to see everything that the investigation team has seen, good, bad, and in between. So a lot of times that's one of many reasons that goes into the decision of whether you do an oral versus a written report. But let's talk a little bit about kind of that communication and that kind of tension and what you've seen done to mitigate that concern, but still get the audit team and obviously the forensic team over the hump on signing off.
Yeah, and that's kind of a tension that you deal with in every investigation that I'm doing, when I'm doing the investigation or when I'm on the shadow investigation side. From the shadow investigative or the audit perspective, first of all, we're not attorneys, we're forensic accountants or accountants. So any kind of conclusions around what's privileged or what isn't, that's not something that we're not equipped to make those decisions. Where we are coming from as the auditors is the position that this is part of the audit. We will need sufficient audit evidence to complete our audit and conclude upon the accuracy of the financial statements. In most contracts that I've seen between companies and auditors, when they're hiring their auditors, most of the time you'll see some kind of clause that the company will say, yes, we'll provide you sufficient audit evidence to do your work. And so that's a kind of a contractual thing. Where we come from is we need the sufficient audit evidence to conclude upon the financials. Whatever information the shadow investigative team thinks that they need to do that, we're going to need that information. The question then becomes, how do we get that that information, right? And in those instances, we look to the investigative team, the attorneys, to come up with suggestions as to how they're comfortable with providing us the requisite information in a way that they believe they're protecting privilege. And I've seen attorneys agree on how to do this, and I've seen them disagree on how to do this. So I can't tell you what's right or wrong, but I can tell you what I've seen is, when you're reporting out, most of the time these days, the investigative team will prepare. Well, they will almost always give us verbally, here's our conclusions, here's the process, here's the conclusions. It will be verbal. Sometimes they will prepare a slide deck, a PowerPoint to go along with that. Sometimes you'll see the investigative team turn over that slide deck. Many times you'll see the investigative team say, I'll show you the slide deck. You can take your own notes, but we don't want to provide it to you. As long as we can get the requisite information from either the deck or from the verbal report out, that's okay. We can take notes, we can create our own work papers, and we can accept that. So on the report out, that usually isn't that big of a problem. What you see really when it comes to sticky situations around privilege is throughout the process, right? When you're getting downloads of, say, maybe interviews, right? The investigative team interviewed somebody and they're reporting to us, here's what we asked, here's what they said. Sometimes, we'll ask questions. Well, what was your mental impression of that? What did, and there'll be times where the attorneys don't want to give that to you, or they don't want to tell you everything that was said in an investigation because it could be privileged. And so, we have to work through those. And sometimes it's a question of, okay, well, as the audit firm or as the shadow investigative team, can we live without that information? And if we can, then that's fine. We're not here to hurt the client or anything like that either. If we think, no, we absolutely need this, then we've got to figure out how to get through it and get the information. And, really, I've never been in a situation where we weren't able to work through the privilege questions or issues in a way that precluded us from completing the shadow investigation. Some just may have been more painful than others.
Yeah, no, I think that's right. I mean, thankfully, there are anomalies, but I mean, the concern is real, right? I mean, there are cases out there where the SEC in particular has gone and sought, the production of internal, interview memos that were prepared by the lawyers because the allegation was that in discussing the interview and the mental impressions with the auditors, you waive privilege and subject matter waiver, and so turn over everything. And most companies aren't going to want all of those
no, it's an unhappy
turned
prospect to think that you are building the torpedo that's going to be launched
That's right.
at your ship.
No, for sure.
Yeah, and as the company's auditors, we don't want. I mean, doesn't serve us any way to help build that or force that torpedo to be built. I mean, look, sometimes we get the information and it's not in the most efficient way, right? You could just show us your notes or or something like that. And a lot of times, the attorneys don't want to do that. So they have to sit there and read their notes to us, and we have to take them,
Right.
Take our own notes. And there are things like that counsel has said that they were willing to do to get us the information. And it may not be the most efficient way, but it's the way that in which they're most comfortable, so as to protect privilege. And we're fine with doing whatever needs to be done. The bottom line for us is we just need sufficient audit evidence.
Makes sense.
That's right. Well, Jeff, this has been a great conversation, and I know there's we could talk about this for another hour, get into all the nitty gritty, but, this has been a great conversation about, these investigations. It is an interesting world that I think a lot of people who don't do this for a living don't even know exists. And those who do, it's kind of this constant tension, not necessarily because the auditors are, adverse, but it's this tension of all these issues that we've discussed on this. And so kind of navigating this is, there is some science to it, but there's a little bit more art form as well. So,
Exactly.
but thanks for joining us today. And for our listeners, you can get this episode and all other episodes of Sidebar on the Bracewell webpage and anywhere else that you get your podcast. Thanks for listening, and thanks for subscribing.